Thank you, Mr. Akubara and Mr. Manduka. It's really productive to have your much information and thoughts about your introduction on the perspective of Nigeria. And actually, due to limitation of time, I would like to spend less time than I have expected, because many perspectives of China's law system is quite similar or share many things in common with the law system in Nigeria. And as to the framework of debt collection or debt recovery in China, there are also many things in common. So I would not like to spend too much time or on the things you have introduced. So I will put something I understand interesting to emphasize such interesting things and skip other schemes I understand. So as to debt recovery, there are some general principles here. And as Mr. Akubara has introduced in a very comprehensive way, especially citing some items of dictionaries, citation or definition, I understand debts in China to be collected is all of those legitimate debts to be collected. It can be debts arising from trades, licensing of trademark, or loans or other things. So that's the common ways we share with Nigeria. But here's some special things to collect debt in China. Because I understand the first thing is that you need to ascertain who is the debtor. It seems absurd or something very strange. Who is the debtor? I should know that. But actually, in many cases, that's the first difficulty for Nigerian businessmen or businessmen from other countries to make sure, because you will find that Chinese businessmen, they send you emails or call you in name of an individual. And later they sign a contract with you in name of company A. And then they deliver the good or collect your payment in name of company B. So who is the debtor? That is the first thing you need to settle. And that's the first job of Chinese lawyers. So I understand, fully agree with Mr. Manduka and Mr. Akubara that lawyers are important in both China and Nigeria to handle cross-border transactions. And the second one is that you need to show to your debtor that you are serious and you can reach him or her. Because I understand most cases, debtors in China, they are not willing to pay the money back to our counterparts, because they understand you have no way to reach me, and you have no lawyers to help you, and you do not know what to do in China. So I just conceal your money and will not pay back to you, and you have no ways, you have no powerful means to recover that, and they disappear. So the second principle is to show that you are serious and you can reach him. And the third and fourth points, I understand, have already been shared by Mr. Akubara, that you need to know the credit and property of the debtor. And finally, make a comprehensive plan before you take any action. Why? Because let's come down to specific methods and tell you why. Actually, the first step to recover your debt in most cases is to send an attorney's letter and have an oral notice to the debtor. That is not necessary or mandatory under Chinese law, but in many cases, that is the first step. Why? Because in a comprehensive plan, maybe you cannot ascertain the debtor at the beginning in law. And by sending attorney's letter and give oral notice to the debtor and get in contact with them, you can try to collect evidence about who is the debtor and show them we can reach you. So that is quite interesting, that this is unmandatory method or means to collect debt, but it can help you to go on with litigation or other means of debt collection. So that is the first step, and is the very good example to show the importance of making a comprehensive plan. And the second step, generally speaking, I understand once you have sent your attorney's letter to the debtor and you do not get any positive response, you need to consider the possibility of litigation. It is very interesting, as Mr. Okubara introduced, there's a credit bureau in Nigeria, right? But I must be honest to say that many functions of the credit bureau in Nigeria has already been taken by the court in China. They can publish a blacklist of dishonest debtor, or the debtor who are not willing to pay after a judgment is made. But the premise is that you need to get a judgment from the court at the beginning. Then you can initiate such measures about credit. So going to the court and initiate a litigation is a very serious method you need to take into consideration at the beginning before you take any actions to collect your debt. And I would just give a very, very short introduction about China's court system and the basic framework of Chinese civil proceeding or civil litigation. China has a 4-level court system, and all the courts in China, they take the same law system. No matter common law or civil law, no, in China, there's only one system of law, and all the courts, they just take the same, they just work the same ways. About 4-level system, court system, we have only one Supreme Court in China, and we have 32 high courts located in different provinces, and over 400 intermediate courts in big cities, and over 3,000 primary or basic courts in China. And most cases will be filed before the primary or intermediate people's courts. As to high courts and Supreme Courts, they generally hear cases of appeal, or they take other work such as formulating some quasi-law regulations. We call that judicial interpretations. That is to harmonize how different courts in China, they understand provisions of law, but it has almost the same effect as law. And most cases will be closed within 2 instances. So that means your cases will be heard by 2 courts in most cases, but if no sides appeal, only 1 instance will make the judgment effective. And about the jurisdiction, different cases will have different connecting factors to define the jurisdiction, which courts have jurisdiction over a kind of case. But in most cases, the court at the defendant's residence has jurisdiction. As to the general process of a litigation case, we will not spend much time here because it's quite complex, and we have the process of case filing, service of process, and pre-trial preparation hearing. And after the hearing is closed, the court will render and serve the judgment, and each party, they can appeal. Mr. Okubara introduced the time limitation or the general period for court to render a judgment. But in China, such period is sometimes hard to predict, because different cases will have different aspects or different plot lines, and the complexities of different cases vary from each other. So, but in China, most courts, they will try to close their case at the end of the year, because that is a very important factor to evaluate the work of different judges. And in the process of litigation, it's quite important to know that you can try to seize or seal up the assets of the defendants before a judgment of effective judgment is rendered. This is a picture that the court clerks and judges, they went to a property, to an apartment of the defendant, and they just seal it up with the kind of high-tech appliances, which will give alert to the court if anybody will try to enter this apartment after it is sealed up. So here we call that property preservation in China. And it is somehow like other writs or say injunction writs in other countries. You can try to understand that in this way, but here the interesting thing is that this property preservation can be conducted online in most cases. What does that mean? We will go through this in the procedure of enforcement to introduce that. And if you want to apply for property preservation, you need to provide clues of property. Otherwise, the court will not take action in most cases. And the guarantee is needed to make sure that if you apply for property preservation wrongly, the defendant will get compensation from the guarantee. For example, from an insurance company or else about the damages or losses they suffered from your wrong property preservation. And about how Chinese court they charge about the court fees. Well, they take a progressive rate, just like individual income tax or something else. And I understand the average fee rate is about 1% for cases ranging from 1 million RMB to 5 million RMB. If the dispute amount is in such a range, the progressive rate will just come down at about 1% of the dispute amount. And here about arbitration, well, it's quite shocking for me that Mr. Agubara introduced the arbitration in Nigeria is both flexible and not that mandatory. Each party, they can even escape or fail to appear before an arbitration proceeding. Well, in China, arbitration is a dispute resolution method in parallel with litigation, but it is also mandatory because the arbitration award can be enforced just like a judgment made by the court. And the procedure is flexible, but still somehow similar to civil litigation in China. So arbitration in China is still very powerful, and you need to take much care about that. And the premise to enter into arbitration is that you need to have an arbitration agreement or clause in the contract. And if you have such clause, you cannot go to court, but rather you need to go to arbitration, right? And the property preservation is also available here in arbitration, just like what you can do in litigation. About settlement and mediation, Mr. Maduka has introduced that as a kind of way of risk management. And Mr. Agubara also introduced that it can be conducted, I understand, before or during the proceeding of litigation or something else. While in China, settlement and mediation can be conducted before, during, or even after litigation and arbitration, because after an effective judgment or arbitral award has been rendered, in most cases, you need to go into the proceeding of enforcement or execution, as Mr. Agubara used the term. But in such proceeding, you can also still settle with the opposing party because they may fail to have enough money to pay back to you, and you can extend the time limitation to pay say for 10 years or even longer than that. So after litigation and arbitration, maybe it is still necessary to try to settle the case, settle the enforcement or execution proceeding. And as to mediation, well, the difference between settlement and mediation is that mediation is presided over by the judges or the arbitral tribunal. But the final result is quite similar compared with the result of settlement. The one thing, or the most important thing you need to pay attention to is that the enforceability of the result of settlement or mediation. Because if you settle a case with the opposing party without the help or without being presided over by judges, such settlement agreement is not enforceable, which means that you still need to go to court or arbitral institution to file a case to make sure that the opposing party did not perform the settlement agreement. And after a judgment or award is rendered, you can apply for enforcement. That is quite time-consuming and very complex for you. So what we would like to advise our clients is that it's more recommended to have mediation, to have all the process being presided over by judges or arbitral tribunals. And then you need to get a mediation statement rendered by them. And such statement is enforceable. You can just apply for enforcement if you find the opposing party failed to perform. Here, I think the most interesting part of my slides is about the enforcement of China. Why? Because enforcement in China is somehow a very powerful proceeding, and it is supported by the violence authorities, say courts, say policies of courts, and say other departments who supported or help such procedure. And enforcement is the power and duty, both the power and the duty of the court only. The parties, you cannot try to enforce a judgment or an arbitral award by yourself. That is not allowed under Chinese law. You need to apply to the court to conduct enforcement. As to the methods of enforcement, of course, they can try to track down and freeze the properties of the defendants, the losing party. They can auction such properties, and they can do the procedure of liquidation, return the money got from the auction and to the winning party, and got the remaining parts to the losing party. And they can also restrict on consumption and other unnecessary acts of the losing party. There are also a possibility of seeking criminal punishments against the losing party. It seems quite a big task or project for the Chinese courts. And how can they make that? Well, here we need to especially emphasize the great help from the online system of enforcement in China. What is that? Well, like we can see from the name, it's an electronic system connecting different systems of government authorities, air companies, or some other necessary entities or organizations to help and support courts to find, freeze, track down, auction the properties of the losing party. Judges in China, they can just click their mouses in offices to find how many bank accounts you have under your name and how much money do you have in each account. And they can just still click the mouse another time and freeze your bank account in the amount that is applied by the plaintiff to do property preservation, or under the or as requested by the application of enforcement to freeze your account and then, like I said, repatriate it or transfer such money to the winning party's account. Everything can be done. Almost everything can be done by the help of electronic system. And thanks to such system, I think about 4 years ago, Chinese courts have already made very, very big achievements thanks to such system. They have frozen a total of almost RMB 300 billion of assets or properties through this system and conducted more than 747,000 online auctions. The auctions even can be conducted online thanks to such system. And they recovered about over 500 billion RMB through online auctions. And they restricted about 19.85 million person times to travel by air or high-speed train. You cannot buy an air ticket or ticket of high-speed train if you have been put on the blacklist of the court system. Only in this way, the enforcee or the losing party, they cannot escape from enforcement. Otherwise, you cannot punish them, and the court judgment is not that powerful. So Chinese courts, they spend much effort to contribute to the power of court judgments. And the final part is about the recognition and enforcement of foreign arbitral awards and foreign judgments. Well, like Mr. Ogubara said, used the term registration of foreign courts. We call that recognition and enforcement of foreign judgments and arbitral awards in China. And as to the arbitral awards from foreign countries, it's quite similar with Nigeria, that China tried to recognize and enforce foreign arbitral awards based on New York Convention. And the Supreme People's Court of China, we call that the SPC. They have a very strong support to recognize foreign arbitral awards. And such cases will seldom be dismissed and was seldom dismissed in history. Also, property preservation is available here. In only very limited reasons or causes can such application be dismissed. Due to limitation of time, we will just skip this part and let's come to the final page. I understand about the foreign judgments. Sorry, we have no treaty with Nigeria about recognition and enforcement of each other's judgment. And Mr. Ogubara, you are right. You need to set down, make sure there's a reciprocity relationship between China and Nigeria, and then have your judgment being recognized in China. But such cases, well, up until now, I understand no such kind of cases can be searched out. I understand, but China has now adopted a much more friendly attitude to recognize judgments from all other countries, not only Nigeria, but also other countries from Africa, South America, North America, all around the world. Sorry, we have no more time here. You just need to set such a idea in your mind. You can just try to do that. As to the more detailed ways, let's have another webinar or another meeting to discuss this, okay? And finally, just need to remember, you can apply for property preservation once you start your proceeding. So, sorry, Dr. Yu, I just need to transfer my microphone back to you, and let's see if there are other questions from Q&A session.